Michigan Constitution of 1963, Article 6, Section 16. One or more judges of probate, as provided by law, shall be nominated and elected at nonpartisan elections in the counties or the probate districts in which they reside, and shall hold office for terms of 6 years and until their successors are elected and qualified. In counties or districts with more than one judge, the terms of office shall be arranged by law to provide that not all terms will expire at the same time. Section 17. No judge or justice of any court of the state shall be paid from the fees of his office, nor shall the amount of his salary be measured by fees, other monies received, or the amount of judicial activity of his office. Section 18. Salaries of justices of the Supreme Court, of the judges of the Court of Appeals, of the circuit court judges within a circuit, and of the probate judges within a county or district shall be uniform, and may be increased but shall not be decreased during a term of office, except and only to the extent of a general salary reduction in all other branches of government. Each of the judges of the circuit court shall receive an annual salary as provided by law. In addition to the salary received from the state, each circuit judge may receive from any county in which he regularly holds court an additional salary as determined from time to time by the Board of Supervisors of the county. In any county where an additional salary is granted, it shall be paid at the same rate to all circuit judges regularly holding court therein. Section 19. 1. The Supreme Court, the Court of Appeals, the Circuit Court, the Probate Court, and other courts designated as such by the legislature shall be courts of record, and each shall have a common seal. Justices and judges of courts of record must be persons who are licensed to practice law in this state. 2. To be qualified to serve as a judge of a trial court, a judge of the Court of Appeals, or a justice of the Supreme Court, a person shall have been admitted to the practice of law for at least 5 years. This subsection shall not apply to any judge or justice appointed or elected to judicial office prior to the date on which this subsection becomes part of the Constitution. 3. No person shall be elected or appointed to a judicial office after reaching the age of 70 years. Section 20. Whenever a justice or judge removes his domicile beyond the limits of the territory from which he was elected or appointed, he shall have vacated his office. Section 21. Any justice or judge of a court of record shall be ineligible to be nominated for or elected to an elective office other than a judicial office during the period of his service and for 1 year thereafter. Section 22. Any judge of the Court of Appeals, Circuit Court, or Probate Court may become a candidate in the primary election for the office of which he is the incumbent by filing an affidavit of candidacy in the form and manner prescribed by law. Section 23. A vacancy shall occur in the office of judge of any court of record, or in the district court by death, removal, resignation, or vacating of the office, and such vacancy shall be filled by appointment by the governor. The person appointed by the governor shall hold office until 12 noon of the first day of January, next succeeding the first general election held after the vacancy occurs, at which election a successor shall be elected for the remainder of the unexpired term. Whenever a new office of judge in a court of record or the district court is created by law, it shall be filled by election as provided by law. The Supreme Court may authorize persons who have been elected and served as judges to perform judicial duties for limited periods or specific assignments. Section 24. There shall be printed upon the ballot, under the name of each incumbent justice or judge who is a candidate for nomination or election to the same office, the designation of that office. Section 25. For reasonable cause, which is not sufficient ground for impeachment, the governor shall remove any judge on a concurrent resolution of 2/3 of the members elected to and serving in each house of the legislature. The cause for removal shall be stated at length in the resolution. Section 26. The offices of Circuit Court Commissioner and Justice of the Peace are abolished at the expiration of 5 years from the date this Constitution becomes effective, or may within this period be abolished by law. Their jurisdiction, compensation, and powers within this period shall be as provided by law. Within this 5-year period, the legislature shall establish a court or courts of limited jurisdiction with powers and jurisdictions defined by law. The location of such court or courts and the qualifications, tenure, method of election, and salary of the judges of such court or courts, and by what governmental units the judges shall be paid, shall be provided by law, subject to the limitations contained in this article. Statutory courts in existence at the time this Constitution becomes effective shall retain their powers and jurisdiction, except as provided by law, until they are abolished by law. Section 27. The Supreme Court, the Court of Appeals, the Circuit Court, or any justices or judges thereof shall not exercise any power of appointment to public office except as provided in this Constitution. Section 28. All final decisions, findings, rulings, and orders of any administrative officer or agency existing under this Constitution or by law, which are judicial or quasi-judicial, and affect private rights or licenses, shall be subject to direct review by the courts as provided by law. This review shall include as a minimum the determination whether such final decisions, findings, rulings, and orders are authorized by law, and, in cases in which a hearing is required, whether the same are supported by competent, material, and substantial evidence on the whole record. Findings of fact in workmen's compensation proceedings shall be conclusive in the absence of fraud, unless otherwise provided by law. In the absence of fraud, error of law, or the adoption of wrong principles, no appeal may be taken to any court from any final agency provided for the administration of property tax laws, from any decision related to valuation or allocation. Section 29. Justices of the Supreme Court, judges of the Court of Appeals, circuit judges, and other judges as provided by law shall be conservators of the peace within their respective jurisdictions. Section 30. 1. A judicial tenure commission is established consisting of 9 persons selected for 3-year terms as follows. 4 members shall be judges elected by the judges of the courts in which they serve. 1 shall be a court of appeals judge, 1 a circuit judge, 1 a probate judge, and 1 a judge of the court of limited jurisdiction. 3 shall be members of the state bar, who shall be elected by the members of the state bar, of whom 1 shall be a judge, and 2 shall not be judges. 2 shall be appointed by the governor. The members appointed by the governor shall not be judges, retired judges, or members of the state bar. Terms shall be staggered as provided by rule of the Supreme Court. Vacancies shall be filled by the appointing power. 2. On recommendation of the Judicial Tenure Commission, the Supreme Court may censure, suspend, with or without salary, retire, or remove a judge for conviction of a felony, physical or mental disability, which prevents the performance of judicial duties, misconduct in office, persistent failure to perform his duties, habitual intemperance, or conduct that is clearly prejudicial to the administration of justice. The Supreme Court shall make rules implementing this section and providing for confidentiality and privilege of proceedings.